Hey guys, welcome to the show. Who knows who said that? Montel Williams. I'm not Montel Williams. I'm Daniel Clotfelter, and I have my sidekick, Bonnie Lilac, who is pushing the buttons today. That's what she likes to do.
Good morning.
And, good morning. And I just want to tell people, because there's going to be people that watch this in a recording, and I want to share how this comes about, like how we came about on our strategy partners calls. And usually they're closed, but we're going to put this out, and we invited some other people to it for new faces. But it comes from my personal belief that we all do better once we know better. And we really can't do better until we've been introduced and exposed to something to do better. So if I share a system with you that's better, you're most likely to implement that system. And what I want to do is give access to experts that I talk to all the way across the board, professional, everything from attorneys to CPAs to anything that, roofers, anything that we need in our business. And we all need, like these wills and estates. This is super important for everybody. And talking about an expert that we've got access to today, and there's going to be 2 more videos. There'll be 2 more weeks, 3 weeks in total. So we'll get through as much as we can get through. But Andy Hartman is here, and I was thinking he's going to be sharing with us. And I was thinking how long I've known Andy. It's been over 20 years, dude. Like, I can't believe that when I was thinking about that and, sharing this with everybody. But anyway, what I respect most about Andy, we'll put his links in there for his business, but he has scaled a law firm, hartmanlawfirm.com, to 7-8 offices. He has so many people, clients that admire him and his work and his team. He has great marketing. He has the closey around the world. He has the Top Gun / Top Pin, which was fabulous. And he's got an ice cream / candy shop in most of his offices. Totally out of the box for most closing attorneys. What I admire really, though, is not just how financially and well he scaled his business and how he's helped in the real estate world. He is a fabulous husband to his wife, Anna, and he's probably the best father I've seen to his son, Sam. And Sam is now a teenager, so I can't wait to watch this. So without any more to do, Andy, take it away for our time.
Well, first of all, that was probably one of the nicest introductions I've ever had. I regret that you weren't at my wedding. I would like you to speak. I want you to speak at my funeral, please. Hopefully that's not for a very long time. But I echo those sentiments with you, Daniel. I've known Mr. Clotfelter since we were both young pups in this business. I've actually known Bonnie for a really long time as well. Daniel and I have hung out socially, and we know where all the bodies are buried. But really, when he and Bonnie, sort of explained to me what they were doing with these meetings with you guys, I was all in, because I think anytime you can add value to a relationship, really that's the cornerstone of my firm, is providing value outside of the closing process. And I think what you have in Daniel and Bonnie as well is you have 2 people that want to give you content and information that works not only in your professional life, generating more leads and business contacts, but things that you can take to your own home place and can help your own family, which is pretty cool. I guess our format today that had been set up was to discuss estate planning, in a general sense. And I have a more focused 1-hour presentation that I do on what to do when you have a deceased person on your title, or someone that you're about to have under contract that you happen to know has a deceased spouse that we may have to address. Are you guys seeing the screen share?
Yes, sir.
Okay. But we can take this presentation that I have and sort of meet it out over the next few meetings in the next few weeks and make this a very casual conversation. Some of the things that we don't discuss in this particular PowerPoint are some of the more basic estate planning maneuvers that you need to make, and you can advocate for your clients as well, as far as actually having a will, and having a durable power of attorney, and also an advance directive, which a lot of people call a living will. So those are some of the types of things that Daniel wanted to discuss that will have broader application, not only for your client representation, but for your own family planning as well. So I'm gonna lob it back to you, Daniel. You tell me, what do you want to talk about first? I mean, I can start going through PowerPoint slides, and then that's going to take on a life of its own. But did you want to talk preliminarily about your experiences with estate planning, or what you feel like your circle needs to know about.
Well, I wanted to, and we don't have to do this today, but I wanted to kind of go through in this series what initiates probate, what can stay out of it, what has to go through it, the reasons why, and basically that was one of my main topics, and then also what agents need to know and what they need to do when there is a deceased party and they're trying to get real estate sold, that kind of stuff. So it's just kind of open forum. Everybody else can ask questions, type questions in as well.
Okay. I'm, for whatever reason, I'm not seeing the chats. I guess I had to make a choice with screen sharing, but if something comes up in chats, either Bonnie or Daniel, that you want me to address, just tell me to stop.
Okay.
Talk over me. That's fine. So I'll just jump into it here. Every different business, whether it's insurance, investing, real estate, child rearing, every different aspect of life approaches the need for estate planning differently. There are a number of reasons why everybody that including yourselves, should have a basic estate planning package, which does include 3 documents. Generally, you have a last will and testament, you have a durable financial power of attorney, and by durable, that word means that it is a document you prepare right now or during your lifetime as a competent adult, which if you find yourself in a situation where you are incompetent, incapacitated, in a coma, or for whatever reason unable to speak for yourself, that document, by being durable, is still something that your designated power of attorney can use. A power of attorney dies when you die. So we get a lot of people that tell us that, oh yeah, my mom owned the property, she died, but I have her power of attorney. No, you don't. Not anymore. Once somebody dies, the document is worthless at that point. And then you have your living will, which basically is your do not resuscitate, or gives all those wonderful things we love to talk about end of life decisions. Not really applicable here, but it is something that is just as important as the other documents. Anybody that's been there for the last few days of somebody's life knows how important that document can be to their comfort and their wishes, and to keep the family fighting at a minimum, if you can. But in terms of real estate, how do we approach it? So those of us in the real estate field, which is me and you and lenders, and your buyers and sellers, we have to approach estate planning with an eye toward buying or selling property, right? Okay, so the first thing we do, when you tell us, or when you advise us that we have a closing coming up where we have a seller that may be deceased, or somebody on title that is deceased, we go into our own means of evaluating that. And come on now, don't freeze up on me. Okay, so when you tell us that we have a title holder is deceased, we're gonna approach it systematically. We have checklists. Our first consideration is who owns the property and how is the title held. You may find yourself in a situation where the person that you has approached you to list a property and sell it is not on the title at all, or they are on the title. However, the title is shared with another individual, a spouse usually, who is deceased. Okay. Here are the 2 most common how propositions. You're either gonna find that property is held as joint tenants with right of survivorship, and I know all of you know what that is. It's my understanding you go over that in comprehensive detail in your real estate licensure, but we'll get into that a little more anyway. If you're not holding as joint tenants with right of survivorship, you're holding as what we call tenants in common. All right. So let's take a scenario here where we've got a husband and wife, 2 owners, Mickey and Minnie Mouse. We've evaluated the deed, and we find that they own as joint tenants with right of survivorship. Okay. For title to pass to the survivor, when you have a deed that has this language, you have all of the following conditions that must apply. Okay. You have a deed to your sellers. When they acquire the title to the property, that language, joint tenants with right of survivorship, must be in the deed. In the absence of that phrase, the default in Georgia is tenants in common. All right, your 2 individuals on title must still be married. A divorce decree will nullify the joint tenancy with survivorship provision, the presumption being that if you get a divorce, you are not then wanting your share of that property to automatically go to that spouse. Okay. neither party can have granted any ownership share or interest in the property by themselves to a third party. If Mickey and Minnie own as joint tenancy with right of survivorship, and let's say Minnie on the side has a little thing with Donald Duck, and Donald she shoots Donald Duck over an interest in the property, her interest or all of it or part of it, that joint tenancy provision has been breached at that point. Also, we need a copy of the death certificate. So at any time when you have a closing coming up where you have a deceased person, and if we tell you that it's joint tenants with right of survivorship, and then which means everything's fine, no probate is needed, the closing still cannot proceed until we've got a copy of the death certificate, because we have to show the rest of the world why we're proceeding forward with only one of the two people that are listed on the title. And we file an affidavit, attach a copy of the death certificate. We can redact private things. We don't necessarily have to have in there how they died or certain other things, but we have to be able to prove of public record that we did possess and have a copy of the death certificate. And by providing that affidavit, you save yourself and your buyer, your seller and your buyer, and us from getting phone calls about it in perpetuity. If all of these apply and your co-owner under the deed is still alive, we just record that affidavit of survivorship and they can proceed to closing, no issues. Okay, and this is an example here. If you look in this deed, on the second line of the deed, you see after Mickey and Minnie's name, you see as joint tenants with right of survivorship. Now, Bobby, I don't know North Carolina law. I assume that this is something similar in your state.
It does. It looks the same.
Okay, yeah, I guess I should say that everything I'm doing today is based upon my knowledge of Georgia's real estate law, and as limited or as expansive as that is the limit of it. So if things vary in your state, just keep that in mind. Okay. All right. So these, this is the general language in here. It makes reference to Official Code of Georgia 44-6-19, being that the intention of the parties was to create for the grantees a joint tenancy estate with survivorship. It's important as closing attorneys that we actually ask your folks if they want that. We have a number of situations when closings occur where you only have one of the two spouses being the borrower. And so in that case, many times the lender doesn't want the other spouse on any of their documents. So you need to make sure your closing attorney is asking your buyers at the table, hey, Bob, I noticed you're our borrower and you're our buyer today. Are you going to want to add Joanne as a co-owner? And it's something you might do privately to the side and just sort of let us know, because sometimes you'll find out that there could be reasons why they do not want to add that spouse. If that spouse has credit issues, judgments, liens, if they themselves are recently divorced, there could be reasons to leave them off the title for a while. All right. Yeah, I tend to talk ahead of my slides, so we already talked about this. All right, so here's a death certificate, for example. Somebody that helped me put this together thought it'd be clever to say that Mickey died by being caught in a mousetrap. So we can redact that kind of stuff. We don't have to let all the other mice of the world know that Mickey was stupid enough to get himself caught in a mousetrap. So, all right. So what do we do if all of the owners on title are deceased? Let's say in your scenario, your seller is a daughter, and she says, yeah, I'm selling mom's house. And that's how she comes to you. And then your next question is, well, do you have authority to sell the house? Oh, yes, she gave it to me. And you're going to hear that kind of stuff. And don't be lured into the confidence that your sellers have that everything is good, because it's quite often not. Just because mom gave me the house, that could mean that she read that in a will, which may need to be probated. It could mean that mom told her that verbally and that there's not even a will. Okay. But those of us in our business need paper trails for things. Okay. So let's say that we have title held by joint tenants with right of survivorship and all of the owners have died. Okay. The first thing we'll do is we need to record a death certificate for the one that died first, because that one we don't have to probate. It's just like the other situation. When you have joint tenancy with survivorship language, the moment of death is when title transfers to the surviving co-tenant, co-owner. So at that time, that's when the survivor owns it by themselves. There's nothing to worry about with that. but we still, in order to have a transaction, we have to have that death certificate and we have to file that affidavit so that the rest of the world knows that the property was at that point owned by just the one surviving co-tenant. Okay. However, we have to take a look at the estate of the one who survived. The one who survived longest or did not die first is now the owner of the property. And what we do from here depends on a few things. Did your survivor, did mom in our example, have a last will and testament, or did she die intestate? And that means simply that the person died without a last will and testament. We also can look at how long ago the person died and how cooperative the heirs will be with each other and with you, the realtor, or myself, the closing attorney. Okay. When we can answer these two questions, we can set a course of action to get to closing, because even at this point, we don't always have to probate to move ahead. Okay. But let's touch on tenants in common real quick first. Okay. So let's say in our scenario with Mickey and Minnie that they held as tenants in common per the language of their deed. And like I said, if joint tenancy is not in the deed, then it is presumed to be tenants in common under Georgia law. It does not have to say the words tenants in common. Okay. So here we are back to our deed. And on the second line there, after Mickey and Minnie Mouse's name, there is just nothing. There's no joint tenants with survivorship, and it does not say tenants in common. And in that case, this is a tenants in common deed. Okay. So if they own as tenants in common, Minnie's going to have a few more hoops to jump through to sell or transfer the property upon Mickey's death. Okay. And those things depend on, again, whether Mickey had a last will and testament or he died without a will, and how long ago did he die, and how cooperative are the heirs, which could be Minnie's children, could be some of Minnie's children, some of Mickey's children, if they are a blended family. Those things become very important in how we proceed. Okay. Do we always need to probate? As I mentioned, no, we don't always have to probate, even if they hold as tenants in common. Okay. Probate can be avoided if we have a few key facts and circumstances in our favor. All right. If the deceased did not have a will, that's key, and the death was more than 3 years ago, and all heirs are 18 or older and of sound mind, we don't have anybody that is under a conservatorship or, for one reason or another, cannot speak for themselves. And the heirs have to be pretty crystal clean when it comes to having liens against them, or we may find ourselves having to pay off liens of heirs at the closing. All right. If all of those 4 conditions are met, we'll again make a copy and record the death certificate. We're going to record what we call an affidavit of descent, which is something that we prepare as closing attorneys, or if they have a family attorney, we will allow them to do it if they follow the format we need. Has to be witnessed and notarized, signed by at least one of the heirs. Okay. We can also get an affidavit of descent signed by at least one disinterested party who has actual knowledge of the family and the heirs over a long period of time. Typically, we're going to require that this person knew the family for at least 20 years. Yeah.
So what technically is heirs? So is it just direct descendants, or is it grandchildren? What is it?
Yes. Good question. Georgia, as in every state, Georgia has a code section which lists the descendancy laws in the state of Georgia. So yes, your heirs are your children. And if one of your children have deceased, then it is the grandchildren of that child. Okay. If the person dies without children, we look, again, let's presume you had somebody that not only just never had children. Okay. So they're obviously not going to have any grandchildren. You then look to the parents of the deceased person, and they become the next natural heirs. And if the parents of the deceased person have passed, then you spread out to the side and you look to see whether or not the deceased had any siblings. And then you start fanning out the narrative. All right, no siblings. Let's go to first cousins. Let's go to aunts and uncles. And that's the procedure by which you decide who the heirs are. Okay. So then we get a quitclaim deed in that all of the heirs must sign. So what we're doing in this case, in order to have the privilege of avoiding probate, we have, again, first, the person had to have died without a will and more than 3 years ago, or we're not even to this discussion. But if those two things have been met, this is where the cooperation of the heirs becomes so important, because we're going to need all of them to basically sign a quitclaim deed that's going to release their interest in the property, and they're essentially going to have to be agreeing that all of the proceeds from the sale of the property are going to go to one or two particular individuals, depending upon how who your seller ends up being. Okay. And if you got one holdout, if you got one stepdaughter 3 states away who hasn't spoken to the deceased in 15 years, that doesn't mean they're not an heir anymore. And we have had situations where the sort of, we'll call him the grumbling stepchild from the first marriage who disowned dad, 15 years ago and never spoke to him, never came to see him when he was sick. They still can hem up a closing and kind of ask for a check in order, as a condition of signing the deed. It does happen.
This is where we find out how many half brothers and sisters you have.
Yeah, you'll always find out. Okay. But if we have a situation where the person has died less than 3 years ago, which is more often the case, you have to move to probate. There's just not another way around that. Other than something that we call years support, which we will get into briefly. Some of you may have seen that. Okay. So what is an award of years support? Okay. That evolved in Georgia common law, and I'm sure it's the case in other states. Some states call it dower and curtsy. Very, very old legal concepts recognized that a spouse had a duty to protect and provide for his surviving spouse and children, to give them reassurance that financially their immediate wants and needs and necessities would be covered for, in theory, 1 year. What would it take for them to survive in the manner to which they were accustomed, so to speak? Okay, so that's how we got to a concept of year support in Georgia, and it's a way to protect the property from creditors. And there's a number of different reasons why a probate attorney would possibly want to go this direction. So we're just going to look at it real quick, so that if this comes up, and it'll at least be something that you can say you've seen before, although you won't see it much.
And
Okay.
before
Yes.
we move on away from the heirs question, I do have a question going, how far back in the family tree do you go back with heirs?
You only, it's a case by case basis. If, let's say that Mickey and Minnie have deceased and they have 3 children, and those children are all living and they're all competent, you can stop there. Okay, you don't have to jump down to the grandkids and the parents and all of that, because the kids are the heirs at that point. So every situation is going to be different. If one of those children of the 3 are deceased, then we got to look at some grandkids. So every single family situation is going to dictate on its face how far back in that family we have to go to get our quitclaim deeds.
And at what point do you stop looking for heirs? Like, you've got somebody that's never had kids, was an only child. I'm thinking about, just different scenarios, and we may be taking up a lot of time with that, but how far back would you go? Just the aunts and uncles, or would then you go to the cousins of those aunts and uncles? You just keep going until you exhaust it all?
Well, if you've one of the important keystones of this is that affidavit of descent. You're going to have somebody in the family that is going to swear an oath, for which there are severe penalties for perjury and liability. They're going to swear an oath that this is the chemistry of this airship. These are the kids that are alive. That affidavit's going to be critical, because if that person is sort of holding out or lying, or wants to just sort of not mention the child that Minnie had with Bobby's brother over in North Carolina, and we're just not going to talk about somebody and leave them out, that exposes the person that signed that affidavit to some penalties.
I have another question. Is there a possibility? So I've heard about this years and years ago, that the land where Great Sky subdivision is built, there's a 4-acre tract in there that was donated to all the heirs and descendants of the people that owned the Canton Mill lofts, or the Canton Mill. I mean, not lofts, Canton Mill. So they used to have, there's old marble swimming pool up there. They used to go and do picnics and stuff. People that worked at the mill. But there's so many heirs and descendants to that now that that piece of property still just sits like no man's land. And it's almost in the middle of the subdivision.
Yeah, that kind of stuff can happen. There are processes you can go to what we call quiet the title to a piece of property. If you have a deed that has so mucked up the ability for this property to ever be used or transferred in a peaceful manner, then you can go to a superior court through a process called quiet title and ask a judge to, sort of lockbox who owns the property, create some path of organization toward notifying these people, getting it sold. And that's typically what you would do. If I were dealing with that property, I would open a probate on the estate of whatever deceased person that is, and throw notice out there by publication, and have everybody that desires to have an interest in this property come forward and claim it. It's not always that simple. Depends on how the deed is read. But the law disfavors land being tied up for generations like that.
Right. That'd be a cool one to look at and see if it's still that way or not.
Yeah. Well, I think first you should have somebody deed you the property for just pennies on the dollar, Daniel, and then we'll solve it from there.
We'll split it. We'll all get like 10 cents worth of interest.
There you go. Okay. So as far as year support, just touching on it, if the estate is insolvent, let's say that you are dealing with a husband in a situation where the wife has died, the only asset they have is this house. I mean, everything they have is tied up in this house. What little equity they have is tied up in this house, and he's got to now raise some kids and needs this house or the equity from this house to do that. Year support takes precedence over all other estate claims, including funeral expenses, last illness and creditor claims. It's not going to take precedent over a secured mortgage, or if the property is pledged as an asset for any kind of debt, year support will not defeat a secured debt like that. Okay, so let's say that you've got $40,000 in gross asset value of an estate, and the deceased person has medical bills and other unsecured debt like credit cards that are far in excess of the $40,000. A spouse could petition for year support and ask to be awarded $40,000, and in our scenario, all of that equity, all of that value of the estate is actually tied up in the equity of the home. So the home would be the asset that is set aside as year support. But you can set aside many things as year support: stocks, cash in bank accounts, jewelry. I mean, you can identify assets over and above just real estate with this maneuver. Okay. Again, if the estate is very small, if it's so small, let's say the land we're dealing with is just some little sliver of land that's maybe useless to most people. Maybe it's got a value of $8,000 to $10,000, and it's not worth even going through the trouble of selling the land if all the money is going to go to some creditors. So the person would say, look, this value in the estate of my mom is so small. My mom had almost nothing, somehow ended up with this piece of land out in the middle of Alaska that nobody can even build on, but might have some value as hunting land or who knows what. So let's just year support that land just to get it through probate and protect it from other creditors and get it sold. Okay. And of course, in cases where the person who died did not have a last will and testament, sometimes, again, the estate has to be pretty small for this to be worth it. It can be a simpler petition to simply ask for a year support protection for a piece of property than to go through all of probate. Okay. And there's another interesting thing about year support. You have the option when it comes to the property taxes. You can set aside the property taxes that are due on the property for either the year in which the death occurred or in the year of the filing of the petition. And that's a gift, I guess you'd call it, from the state of Georgia, that you can choose one of those years to not pay the property taxes on the residence. Okay. And if you have a situation where the spouse was omitted from the will, or if the spouse was left only a token amount, they can petition the court for year support. You can't disinherit a spouse in the state of Georgia, and you can't leave them only token amounts of asset or funds or money from an estate. A spouse has a spousal share that they're entitled to, and if they have to file for year support to protect what is rightfully theirs under Georgia law, they have the option of doing that. Okay. Real quick to recap the retirements for an award of year support. All of the heirs have to be 18. They have to be properly served with no objections filed. And the order granting the property to the surviving spouse must be recorded. Okay. And let's say we had Fred Flintstone now that has passed. Wilma received an order of year support, granted her the property to she and her child Pebbles, who was 2 years old at the time. Now Pebbles is over 18 years old. The sellers are Wilma and Pebbles, okay? However, if Pebbles was not yet an adult, a guardian ad litem would have to be appointed for her by the court. And that's one of the nuances of an award for year support. Sometimes to get that, the surviving spouse is going to have to agree that the year support award goes not only to her, but to any minor children that would still technically be dependent upon the deceased owner, okay? So you can have a title transferred to a spouse and a minor child, but obviously we hate having minor children on title. That is not efficient, and it is not easy to sell a property if there is a name of a minor child. So pro tip, don't ever let any of your friends or family or clients deed a share of property to a grandchild or even to a child who is underage, thinking that they're doing this as a neat gift or as a way of handling estate planning. It's just not a good idea, because there's multiple hoops you have to jump through to transfer a property that has a deceased child on the title, a minor child on the title. Okay, this is not a good copy at all, but this is generally what a certificate of order of year support looks like. It's a very simple document. It lists the grantee would typically be the persons who are claiming an interest in the property by year support, and then it would list a description of the property and be signed by the judge. Okay. All right. So moving past year support, let's talk about the situations in which you have to probate. Again, if the person has died less than 3 years ago, and those other conditions couldn't be met, you have to go forward with probate. And you're either going to do it in administration if they died without a will less than 3 years ago. Here is the highlights of an administration of an estate. Again, all heirs over 18 and of sound mind. If you have heirs under 18, a guardian ad litem would be appointed by the court. They have to all be properly served with no objections filed. Service is most preferred by the court to be personal service. If necessary, you can avoid service by having them file a really easy affidavit. Those forms are all available in the court. They sign the affidavit consenting to the probate moving forward. It's a notarized affidavit, and then they don't have to be served. If they do have to be served, the court has to propound upon them copies of the documents and receive proof in their satisfactory form that they've been served by a process server or by the return of a signed affidavit. Or finally, service can be by publication if necessary. Then you have an administrator who is appointed and becomes your signer on the contracts and deeds. This is an administrator who's voluntarily stepping forth to represent the family or the estate to move assets through the estate and get them sold. Okay. Once the court gives letters of administration, that administrator is the person that's going to sign your deeds and contracts. There's a period of creditor protection with an estate. It's the first 6 months of an estate being open, generally, that creditors have the right to file claims against the estate. So typically, when you have somebody who, if the probate has not been open for at least 6 months, the estate is going to have to be, the administrator is going to have to be mindful of creditors' rights prior to distributing any funds from the estate to the heirs. Okay? And the transaction needs to be a sale to a bona fide purchaser for fair market value in an arm's length transaction. That again is essentially for protection of creditors. You can't give a property away for a nominal value to a family member, for an example, in the hopes of protecting it from creditors. All right. Very important, the letters of administration. And these are documents that you might help us procure them from your seller, but you're not going to be expected to have to identify and analyze the document in a way that you're not going to have to come to me with all of these check boxes having been checked. Your closing attorneys are responsible for making sure that these documents are in the form they need to be in. So don't ever worry about having to have that depth of knowledge. Just the helpful thing is that if you're dealing with someone who is trying to sell a property and you're trying to help them, but you know we've got a deceased person involved, it's just helpful to know for your benefit to know what type of documents you're going to have to help us get. Okay, the letters of administration do have to say in them that the administrator has the power to sell the real estate. Okay, otherwise you have to go back to the judge again and have another hearing to get permission to sell. And there are multitude of situations where a judge might not feel comfortable with the power to sell. They may want the judge may want the parties to have to come back to him or her for permission to sell the property. Could be a situation where he knows he's dealing with an estate where everyone is mistrustful of each other. He maybe lacks full confidence in the administrator for whatever reason. Maybe they're young. Maybe they are not used to handling administrative matters like this. And so the judge wants the contract brought back to him or her to take a look at the contract to make sure he blesses moving forward and create some ground rules for how the money will be distributed. Okay. There's always an asterisk, right? Like I said, just because the property can be sold doesn't mean the heirs can receive the proceeds of sale. And we had this 6-month protected period. So, when we get to closing, we're going to be making the checks, or the wire transfer is going to be payable only to the estate. So your pro tip as a realtor is to train your sellers in these situations that they need to, at the time they're listing the property, probably go ahead and start the wheels of obtaining an estate bank account, which is going to require them to get a tax ID number for the estate and to be prepared and ready to have those funds go to that account. That your person that is signing the contract, they may be the only one getting any money from this transaction. All their kids are going to sign off on it. No other heirs are going to make any claim. However, that doesn't mean that this individual is going to walk out with a check or a wire in her name or his name. It's the funds may have to go to the estate, and that's really for the buyer's protection and for our protection as a closing attorney. We don't want to have to dive in and make a deep analysis of whether or not it's safe to distribute proceeds to the individual heirs or to the executor. Our seller is the estate, so we're going to distribute the proceeds to the estate. End of story. There are other situations where you might have the property owned by the estate. However, your seller would really prefer to be that heir individually. And there are some cases where we can do a deed from the estate to the individual heir, and then the individual heir then becomes your seller, and we move forward that way. But that again is an analysis that has to be made on a property by property basis. Okay. This is what the letters of administration look like. You're also going to think, okay, well, I've seen something called letters testamentary. That's different. Okay. This is letters of administration. This is a situation where I guess we're dealing with SpongeBob SquarePants now. Spongy has deceased and deceased without a will. Remember, when we're dealing with letters of administration, we're dealing with somebody that died without a will. Okay. This letters of administration happens to be awesome because the judge in this case granted all of the powers. We call them 261 powers. That is inclusive of every possible type of fiduciary power you could have in the state of Georgia when you're dealing on behalf of somebody else or some other entity. Okay, they're called fiduciary powers. This judge granted all those powers to this administrator. So this judge is saying, go forth, sell property, distribute funds, don't come back to me. Come back when you're ready to close the estate, but I don't need to see anything else related to your sale of property for this estate. Okay. I'm not going to get into situations where the court requires a bond, but sometimes the court does require a bond to be put up, and there are bonding companies we can put your seller in touch with, and we would need proof that that bond exists. Just something to put in your back pocket and not worry about. Any questions so far?
Yes, you've got a couple. Can an heir be the administrator as well?
Yes, usually the administrator is one of the heirs.
Okay. And can the property owner state who they would like to be the administrator prior to their death?
They can. Typically they may have done this. The court will consider extrinsic evidence like a letter left behind or an email or some sort of last wishes that were conveyed. However, ultimately, all of the other heirs are going to have to agree through that process of service and consenting to the probate. They're going to have to agree that they also consent to this particular person being the administrator. Okay. If the deceased had a will, that is where they would say who they want to be their administrator, which in that case we call an executor.
Okay. Thank you.
Okay, you got it. All right, so let's jump in. What if, and I don't know how I'm doing on time. If I'm talking really fast because I know we don't have a lot of it. But when you get to,
Where are you in your slides? It's we've been going 50 minutes, so we can wrap it in the next few minutes or whatever,
okay,
and pick it up again next week.
I'm about, I guess, 4/5 of the way through this deck.
So is this a good spot to end it and pick it up again next week?
Yeah. Why don't we do that? Next week we'll pick up and discuss how it differentiates your process when a will is involved, when you do actually have a will.
And the process is to get all that. Well, man, I
Yeah.
appreciate it. I appreciate it. Bonnie, thanks for running the show there. And Andy, I'll give you a call in just a few minutes.
Okay. All right. Well, I guess you guys have administrative stuff, and you're kicking me out, Daniel, aren't you?
Yeah.
I don't get to see how the sausage is made. That's fair.
What do you mean? What do you
thank
mean? You
No,
can see it?
I just like watching you work. But I'm going to go, and I did put in the chat all of my contact information. Any of you ever have questions or need help writing stips, you can text me on the weekend. You can email me. My wife knows I work realtor hours. And to the extent you ever need anything, please consider me a resource for you and for all of your EXP family and friends. Okay.
Thank you.
All right, man, thank you.
All right. Thanks, guys. Bye.
I'll be sharing insightful and informative videos on stress-free retirement, being your own bank, setting up college funds, understanding Social Security, wills, probate, trust, and how the Fed Reserve rate hikes affect your mortgage rates. And always, real estate solutions. I'm your go-to expert in real property. Look for my YouTube channel, living in Canton, Georgia, where it is sunny as can be right now. If you find value here, please like and share so others might as well. Remember, I'm not a videographer, not a video editor. I just want to share the most important info with you guys. Each video has a full version of around half hour or so, but there are multiple shorts of only 5 minutes or less as well. My name, Daniel Klopfelter. My area of specialty is real estate and asset protection for more than 25 years. So why am I exhorting you to view financial-based videos on a real estate channel? Good question. I believe that we all do better when we know better, which is why I'm here to expose you to a team of experts who know the topics that matter most. All of these topics work in unison. Full disclosure, I receive nothing for doing these videos other than the satisfaction of adding value to you. So smash that like button already. What are you waiting for? Share this so other people can see it. Y'all have a great day.